and chartered accountant with a corporate experience of 12 years. Worked as a company secretary in domestic as well as one multinational company. Also liaised with top audit firms like PwC, EY, and Deloitte. Is passionate about teaching and training, so taught various subjects, corporate laws, tax laws, foreign exchange laws, labor laws at all levels of CSCS, CMA. He has teaching and training experience of more than 22 years. Great. Also taught law subjects at various management institutes as well as at academy and e-learning journal on academy. Presently doing extensive research on new labor laws, also providing online training on labor laws, HR manager to compliance officer, CACS advocates, and run a YouTube channel and have more than 70,000 followers. And also is giving different, which has a follower of professors and tax and other officers. Welcome, Mr. Shantanu.
Thank you, ma'am.
Our participants will really have your knowledge, experience, benefit. Thanks a lot. I'll request Sudhakar to say a few words and Mr. Bala, and then we can start the session. Thank you.
Bala, you may go ahead, please, to start with.
Yeah. So shall I start now, sir?
Yeah, please go ahead.
So as we in the last session, we had covered 2 acts. The code on wages we had already covered, and the industrial relation codes we also have covered, right? So now only 2 codes which were remaining. So this session we would like to finish those 2 codes. That is the OSH codes, Occupational Safety, Health and Working Condition Code 2020, and another Social Security Code 2020. So first we will go through the OSH code. In short, we can say OSH code. First, we'll go through the objectives, then applicability of this act, and then penalties. There are a few penalties which are mentioned, and then some important forms which are there. So first, we will see what are the objective of this OSH code. So as we have already discussed how many acts it will subsume, all these things we have already discussed. Now I just want to focus on few things. The objective. So the objective of OSH code is to provide for registration of establishments. So all the establishments should be registered under this code. And very peculiar feature of registration, ease of doing business, you can say, that establishment will apply for registration, and within 60 days, the authority either it should approve the registration, or if there is any information required, they should ask the employer to furnish that. Otherwise, automatic approval system is there. So after 60 days, the registration will be deemed to be granted to the employer. So this is very interesting feature which is there in OSH code. After that, there are duties of employer and employees has been described here. Occupational safety, there are certain provisions related to occupational safety are there. Responsibility of employer relating to health, safety, and working conditions. And then there should be some welfare facilities which should be provided by the employer. These are mentioned. Hours of work and annual leaves, all these provisions are there. And after that, special provisions for women and contract labor. These are also there. Social Security Fund for the welfare of unorganized worker. So this is very important step forward to protect the unorganized worker. So there will be a special fund, Social Security Fund, and this fund will be utilized, and how it will be utilized, the picture is not clear, but this fund will be utilized for unorganized workers. So one of the idea of this setting up of this fund is that whatever penalties the employer will be paying, there may be some penalties which will be going to this fund, and from this fund, the government will try to provide some welfare facilities to unorganized workers. Then after that, there are some requirements relating to register, records, and return. So these are the basic objective of this OSH code. Now, when we come to applicability, So this code is applicable to all the establishments. Now, establishment, they have specifically defined here. Establishment means a place where any industry, trade or business, manufacturing or occupation is carried on in which 10 or more workers are employed. So if in any place where like these activities are going on and 10 or more workers are employed, then this code will be applicable to such establishment. Now, motor transport undertaking, newspaper establishment, audio, video production, building and other construction work or plantation in which 10 or more workers are employed. So similar like 10 here. And the factory, this is very interesting feature. Factory for the purpose of chapter 2, that is registration. Chapter 2 belongs to registration, in which 10 or more workers are employed, notwithstanding the threshold of worker provided under clause W. So basically factory, what we have seen till now, factory की definition में हमने देखा है कि there are 10 or 20 workers with or without aid of power. Now in this code, they have doubled the limit of number of workers in case of factory. So with aid of power, if there are 20 workers, then it will be treated as factory. Without aid of power, if there are 40 workers, then it will be treated as factory. And all the provisions of factories will be OSH code, which are applicable to factory, will be applicable to factory. However, for registration purpose, what they have said that if there is a factory, even with 10 or more workers, then registration process will be applicable. So you have to register, but you may not have to follow the all provisions which are applicable to factory unless until you reach the threshold of 20 or 40 worker. I think this is very important, that registration and the applicability, that will be different things here. Then these establishment will also cover a mine or port or vicinity of port where dock work is carried out. So in case of mine, port, there is no limit of number of workers. If it is a mine, straight away, this code will be applicable. Similarly, in case of port. Employer cannot employ employee without registering the establishment. This is very strict provision that if you are liable to be registered under this code, you cannot employ the employee unless you registered your establishment under this code. Now, there are a few more things like contract labor. There is a part 1 of chapter 11, which deals with the contract labor. The whole part deals with the contract labor. And it will not apply to establishment or contractor having less than 50 contract labor. So it talks about basically the licensing requirement. So if you want to be a contractor providing contract labor, so if you are having 50 or more contract labor under you, then you have to apply for the license. If you are having less than this figure, then no need to apply for the license, contract labor license. This is a separate license under part 1 of chapter 11. So this is the threshold as far as contract labor is concerned. Then there is interstate migrant workers. This is also very important, crucial here. And part 2 of chapter 11 deals with this interstate migrant workers. It will not apply to establishment or contractor having less than 10 interstate migrant worker. So we will see later on that there are certain provisions related to interstate migrant worker. These will not be applicable if the establishment is having less than 10 interstate migrant workers. So this is all about the applicability on the establishment.
Shantanu, one question.
Yes, sir.
Say, for example, if I am not employing the labor directly, but I am employing a subcontractor who will be providing me the labor.
Yeah.
So that all the labor will be under the subcontractor and I am outsourcing that. In such case also, I do need the registration or not required?
Yes, sir. As far as registration is concerned, specifically, they are saying You're talking about contract labor, right? Part 1, applicable
Correct.
license.
Yeah.
50 is the threshold. If you are providing, let's say I am providing contract labor less than 50, so I need not to go for licensing. So because small contractors may be able to do their things without any hurdles or big legal compliance. That is what I feel that may be the
So whether I employ directly or indirectly, whether I
I
employ directly or indirectly, that is through a subcontractor, but still I require the registration.
I think Sudhakar question is simple.
Mhm.
A person is starting a manufacturing, like I want to start a manufacturing unit. I am the only person. I don't want to employ anybody directly under me at all.
Correct.
I employ only contract labor.
Hmm.
That is a point.
Subcontractor is
I
there,
want to get all the job done only through the contract labor. I don't have even a single workman in my company.
Yeah.
So still should I have to register or should I not to have to register?
Register under, you are talking about registration
Factory Act, manufacturing activities.
Yeah,
with
sir, your question, there are two provisions which will be applicable here. First, there is a concept of core activity also.
Yeah.
Core activity, when you are manufacturing something and there is a core activity,
Yeah.
You cannot employ contract labor there.
Mm.
Okay, so you have to employ some normal employees, and which are non-core activities, you can employ the contract labor. So this is very clear picture about this. So if you are starting manufacturing activity, you cannot employ all people who are contract labor. This is what.
No, Shantanu, 1 minute.
Yes.
What
Sir.
I'm trying to say is, I am running a manufacturing unit, right?
Okay.
I will employ my production head. I will employ all the heads of department. I will employ myself.
Okay.
Whereas the other people are concerned, as far as the labor is concerned. Okay, the skilled workers, semi-skilled workers, I am not going to employ them on my payroll. I am going to employ them through a contract labor. So I am appointing a subcontractor. And that subcontractor is providing me the skilled as well as semi-skilled people.
Okay.
I am outsourcing it completely because what I am going to do is I am going to appoint only my senior management. I don't want to get into the rigmaroles of all the what's called middle and junior level management staff. Can I do that? Number one. Number two, if I am going to do, what kind of compliances I have to make under this particular OSH 2020 is concerned.
Okay, sir. So question number 1, as you mentioned, I would appoint heads in the department, and then rest will be the contract labor. So we have to check, let's say there is a production unit and the core activity is production. As per new labor codes, you cannot employ contract labor in those core activities. So this is what my point is. So earlier there might be freedom, but now there is restriction. So number 2 question, what you were saying, that if you employ contract labor, then the threshold, as far there is a separate license you have to take if you are employing contract labor, but that will be applicable only if at any establishment or contractor, both they have to take the license. So if suppose your establishment, you are running the establishment and you are employing contract labor, assuming in non-core activities, which are less than 50, then you need not to go for the contract labor license.
So Shantanu, for my benefit and for the benefit of participants, just 1 minute, Bala, for my benefit and the benefit of participants, can you please clarify what is my core activity and what is my non-core activity, where I can employ the contract labor, where I cannot employ the contract labor?
Yes, sir. So as far as core activity, the concept of core activity is the main activity for which you are establishing your unit. For example, you are making chocolates. So the production process, which will involve so many labor, those production process, you should employ only employees, not contract labor. Maybe labor workers, but not contract labor. Now, apart from other than core, non-core activities have been defined. There is a proper definition, and it is a very long definition. For example, cleaning stuff, you can employ the contract labor. All those activities which are like security. Security is not treated as a core activity. It will be a non-core activity. You can employ contract labor. And there are other activities which are not directly related to your main production. You can employ contract labor in those cases.
Yeah, understood. Thank you.
Yeah, but there is a very big definition. I think we can cover it later on some.
I think maybe we can say that all supporting staff.
Yeah.
Okay, whether it is admin or whether it is non-skilled or semi-skilled, whatever we may call it as, all the supporting staff may come under that particular definition. To understand at a macro level, I think that is how we have to come.
Yes.
So that means the service people, so to say, that is maintenance, security, admin, etc. and other things, service people,
cleaning,
who are not related to main production process. That is what you are saying.
Yes, these will be non-core activities and you can employ contract labor in that.
Sir, can you just clarify the threshold limit of 50%? Is restricted to entity or it's restricted, or like each of the branch should have that?
No, when we say establishment, it is a unit. So one company, there may be different establishment. Okay, 4 or 5 establishment. You have to check each and every establishment. That is the place. Are you getting my point?
For example, suppose I have 40 people in Chennai, rather 60 people in Chennai and 10 people in Mumbai. So the 60 people only I'll have to take the contract labor, or I'll have to go as a overall?
No, so the establishment, suppose in Chennai, you have given 2 figures, 40 and 60. So suppose there are 2 establishments in Chennai, Chennai 1, Chennai 2, Chennai 1, you are having 40 contract laborers, you need not to apply for the license. But if another unit, Chennai 2, you are having 60 contract labor, you must apply for contract labor license.
All right. Thank you.
Yes.
I just have one small query.
Yes.
This is regarding if suppose the entire production arrangement and all those things, if you are taking on leasing arrangement basis, if you have a lease arrangement for any production of some product or commodities, in case of like MNCs, who will be responsible for this kind of regulatory compliance?
Leasing means the person who is going for production activity. For example, I have taken a certain place on lease, and now I'm starting certain manufacturing activity there. It is my responsibility to take the license for that purpose, primary responsibility. But there are certain provisions under OSH where lazy both are made liable to comply certain things. So that we will go into the detail later on. But right now, as far as licensing is concerned, the primary responsibility of the person who is employing or who is doing manufacturing activity, whether it is you have owned the place or you have taken on lease, the person who is doing manufacturing activity, he will have to apply for the license.
There is one question has come actually. Who is responsible for HR compliances of aggregate or home care service? Staff who provide services to patients or customers, can company take the contract labor aggregator saying we are independent contract service and escaping HR compliances?
I think what you are asking me, Mr. Atul's question is there. So there is one particular organization which is providing staffing services like people, right? So the owner of that organization will have to comply. That is, he will be the contractor basically, and the people where these contract labor will be working. So that employer will also have to comply with the related provisions. Are you getting, sir? Either I am not getting your question properly or there is some confusion, I think.
No. So the question is here, can we escape the HR compliances, which is not correct? You cannot escape the HR compliances. Even if you are employing through the third party has to comply with it. And the person who is employing the third party, the employing person has to ensure the third party really complies with it.
Yes. So
that is the point here.
Yeah, basically there will be 2 types of employer, principal employer and the employer. So the person who is providing such staffing services to different organizations, this will be the employer. He will also have to comply. And the principal employer means these person, wherever they will go and work, that principal employer will also have to make sure that these
Yeah,
law.
that is right. Even today, that provision is actually there. In fact, we also used to have a contract employed. But as an employer, what we used to do, we used to call the contractor, we used to check with them. Have you done this? Have you done that? Have you paid the provident fund? Have you paid the ESI contribution? Have you paid this? Have you paid that?
Correct.
If you are not paid, please pay that first before we make the payment. Or we will make the payment on your behalf, deduct from your bill.
Correct.
That is the thing. That is the same thing. There is no question of any escaping the compliances.
In this law also, that is employer, the principal employer will have to make sure as far as payments and everything is being done to those people. If it is not done, then even the principal employer will be liable. So it is the duty of principal employer to make sure that contractor is paying all the dues to the employees.
Rakesh Kumar is asking whether the rules under the labor codes have been enacted. As on today, the labor code is only at proposed, it is not yet implemented because currently the other labor laws are continuing it. The day the notification will come, then only it will get implemented. There are a lot of things, as Shantanu has put it, is not clear today. Once those things get clear, then it will get enough. Today, it is not actually a implemented act. It is under implementation.
Yes, here one point is there. Rules have been, draft rules are available, but these have not been finalized till now. But draft rules are available right now. But we may see certain changes in those rules by the time.
If the employer hire contract labor through the third party, say more than 50 labor, then in that case, employer, whether to take contract license or third party will ensure compliance. No, licensing will be required by both the parties because only the contract labor who is providing the contract, he has to take a license for the provision of the providing the contract labor. The employer who is employing, he is required to take the license if he is employing more than 50 contract labor. That is the position. If it is less than 50, he need not. If it is more than 50, he needs to. That is
basically this 50 you have to check separately. Suppose one employer is employing contract labor through two different contractor, both 25. So employer is meeting the limit of 50, so he will have to go for the contract labor license. However, the contractor who is just supplying 25 contract labor need not to go for the licensing. So these are separate license need to be taken by the employer or the contractor as the case may be, but the limit remains the same, 50.
Vaibhav is asking, if my main business is designing of electronic products, as per the memorandum and article of association, and I appoint the contractor with more than 50 contract laborers for manufacturing those products, so do I need to register under OSH 2020? I think this question he has actually discussed.
I think there are two things, as we have already discussed. The core activity now in future, I mean, once the code will be applicable, in core activities, you cannot apply contract labor.
Yes, that is what he said.
Second thing, if you are employing more than 50 contract labor, wherever you want to employ in your establishment, you will have to go for the licensing under part 1 of chapter 11 for contract labor.
Because one thing is very clear from the talk what Shantanu had. The main business of the company as per the MOA is the core business of the company. You cannot have a choice of employing contract labor. You can employ the contract labor only service supported services, in which case you can go for it. Otherwise, you have to employ necessarily for the main business of the company. So there is no question of going and employing the people for the even the main activities. Yeah. Yes, Shantanu, you can go ahead.
And similarly, interstate migrant workers, there is a part 2 of chapter 11, not apply to establishment or contractor. Again, you have to see establishment and contractor separately. Less than 10 interstate migrant worker, then you need not to comply with those special provision which are given in the part 2. If it crosses 10, you have to comply with those. Okay. Now, there are certain offenses and the punishment. Okay, so there is minimum and maximum. These punishments are prescribed like minimum and maximum. So I will just go through. As you can see, there are a lot of punishments you will see here. General penalty. Now, what I want you to focus on the kind of contravention and the liability which an employer may face. General penalty for offenses. So any contravention of code, regulation, rules where no separate penalty is given, so at least 2 to 3 lakh you will have to pay as a penalty for contravention, and 2,000 per day if it is continuing one. Then punishment for causing, obstructing the chief inspector or inspector cum facilitator. So this is a normal feature. See, inspector's power in OSH code is huge. It may not be the same inspector as we have seen in other codes like code on wages and social security. Here the inspector has so much of power that he can enter into the premises, he can check the safety and etc. And if anyone obstruct chief inspector, then there will be a penalty of 1 lakh, 3 months imprisonment or both. Penalty for non-maintenance of register record, non-filing of returns, there will be 1 lakh to 2 lakh. Punishment for contravention of certain provisions. Now, what are certain provisions? They say is that there are certain provisions relating to prohibiting, restricting, regulating the employment of worker, including women, audiovisual worker, contract labor, employees below 18 years of age in case of mines. So if these special provisions are violated, there will be a penalty of 1 lakh, and second and subsequent offense, there will be a penalty of 2 lakh, 3 months imprisonment or both. These are the things where we were like. Apart from that, punishment for falsification of records, etc. 1 lakh, 3 months. Now I'm just giving all these detail in brief. In quotes, second and subsequent offense, there will be 2 lakh, 6 months or both. Penalty for omission to furnish plans. Now, when you set up your establishment, you have to give the proper plan of your establishment, the production facility, everything. And if you fail to give this information, then there will be penalty of 2 lakh. Punishment for disclosure of information. There are certain information which are very secret type of information. If basically it is for inspector and government officers who come to know about certain information, and if they disclose, then there will be a penalty for on them also, 1 lakh, 3 months or both. Punishment for wrongfully disclosing the result of analysis. There will be certain analysis will be done of sampling and etc. because OSH is all about factory, there are hazardous substances, and there will be so many testing will be done. And if you wrongfully disclose the result of that, there will be a penalty of 50,000, 6 months or like both. Then punishment for contravention of provision of duties relating to hazardous process. Now, this is very important. Hazardous process, wherever hazardous processes are being run, it is very important that you should meticulously follow these provisions, because if you don't follow these hazardous provisions, like provisions related to hazard substance, then there will be a strict penalty. 5 lakh rupees, 2 years of imprisonment. Okay. And there will be 25,000 something per day. Or now, again, they says if this hazardous process, which you had to comply certain provision, if it continues beyond 1 year after conviction, then there will be a 25 lakh rupees fine, 3 years imprisonment or both. Punishment for contravention of provisions of duties relating to safety provisions relating in an accident or causing. Now, this is also very important, because now and then we see that there are certain accidents in a factory. Please note it carefully that employer's duty is to provide all the necessary facilities, safety equipment and everything to all the worker, and not only provide, but he will have to watch for those also, that the people are following those instructions or not. Now, if there is a factory and there is a death of any person because of an accident, then there will be a minimum 5 lakh rupees of penalty and 2 years of jail or both, and 50% or more may be given to victim. This is also very good provision here that in case of a death, whatever penalty employer will pay, 50% may be given to the victim. And this penalty will get doubled if there is a second or subsequent default. So if there is one death due to accident, another death, then this penalty will get double, like 5 lakh will become 10 lakh, 2 years become 4 years, and like that. Apart from death, if there is serious bodily injury due to accident, then 4 lakh rupees of fine penalty, 1 year of jail or both, and second subsequent, there will be double the amount, double punishment. Now, after that, special provisions for contravention of order, general or special under 38. There will be some special order, general or special orders given by the commissioner. And if you don't follow those orders, then there will be a penalty of 5 lakh and 2 years imprisonment. Failure to appoint manager in a mine. So whenever there is a case of mine, you have to appoint a manager. Just like in a factory, occupier is there, you have to appoint a manager in case of mine. And if you don't appoint, then there will be a penalty. Offense by employees. So see, it is not always employer. Even if in your establishment, employees are supposed to take care of all the safety measures. And if the employees are not following that, there may be possibility that these employees will also be charged with the penalty of 10,000 rupees. Now, there is a provision of compounding. Compounding is basically government wants that instead of prosecuting and penalizing, it is better that the employer should comply, ready to comply the provision. So compounding provision is there. 50% of the maximum fine you have to pay in case of only penalty. If there is no jail term, only penalty is mentioned for the offense, then you can pay 50% of that maximum fine, and you can get your offense compounded. So no prosecution will be launched against you, or if it is already launched, it will be dropped. And in case of offenses, when we talk offenses, it means there is a penalty as well as jail term. Then you have to go for 75% pay the maximum fine to get it compounded. No compounding will be allowed if second or subsequent offense is done within 3 years from the date of conviction, earlier conviction or earlier compounding. So there will be some cooling period. You can say today you have gone for compounding. Again, similar offense, next 3 years, no compounding, you will have to face the music. And if there is a gap of 3 years, then you can go for compounding. So amount of compensation will be credited to fund. Now, again, as I mentioned, compounding is allowed, very good, and it is okay. I mean, and whatever proceed you will receive from this composition of offense, compounding, it will be credited to fund, which will be utilized for unorganized worker. So this is very interesting feature, and it is very important, and it will help unorganized sectors also. So apart from this, there are certain, you can say, forms. Now, these forms are mentioned in the rules, okay? And rules are in draft stage. I mean, draft is available. Finalization has not been done till now, so we can wait for that. Now, all these 17 forms are there, and the important one I have highlighted, like application for registration, is the form number 1. Then form number 6 is the format for notice of accident or dangerous occurrence. If anything goes like wrong, you have to report to the inspector immediately. So this is the format. Then 8, register of workers employed in an establishment, wages, overtime, fine. This is also very important register you have to maintain. Then deduction for damage or losses. Any damages or losses which is done by employee, you have to recover. You have to mention a proper record for that in form 9. Then there is a 10th annual return. This is also very important. It is very huge annual return. depending upon the type of industry. If it is hazardous, then there are so many things you have to report in annual return. Register of accident and dangerous occurrences, 11. Register of leave for leave with wages. And 16 is experience certificate of contract employee. This is very interesting to note that contract labor, whenever you will engage contract labor, and at the time of leaving that contract labor, once he leaves, he can ask for certificate, experience certificate, and it will be the duty of the employer to provide that experience certificate in this format, that is Form 16. So this is very good thing about this new labor code, that you can say professionalizing everything. So this is all about OSH. I cannot go into the detail as we have limited time. I don't know what is the time right now.
11:35.
11:35 already done. So these are the things. There are so many things I have to cover, but 1 hour is not enough. So I have just covered few aspects like objective of this act, then applicability, then penalties, and important forms. So this is what we can discuss in 1 hour time, but in detail, if required, we will go in certain aspect like core activity or something like that later on. Just a minute. Now,
see the underlying point in this particular case, if we see the code which has been now introduced, is basically in the interest of ensuring the safety and the health of the employees working in the organization. It is more so in case of the dangerous chemicals or hazardous chemicals, etc. What are the various precautions, etc., which are need to be taken care. That is one. Second thing is compliance part. The compliance part, they have made it very stricter, even in the similar line with the company side, increasing the penalties like anything. So at the end of the day, there is no question of non-compliances. There has to be a stricter compliances has to be there. That is the whole idea of this particular code. As he rightly said, rules are actually under there. So in fact, there are a lot of improvement has taken place between the earlier acts to the new code actually. Compounding is actually a new feature which was not there earlier actually. This is a new feature. And similarly, helping to the unorganized sectors with the fine and penalty which are collected by the government, they'll be aided. We do not know today what form, what is the thing it is going to be, but that is again another feature which is actually coming in. But I will have to wait and see for the rules to come, and when it get implemented, we don't know when it's get implemented. But if it is get implemented, it will do greatly good for all the sectors, especially more so in case of the manufacturing sector. Because I can definitely say this because I have worked in the manufacturing company, which is having about 5 manufacturing units situated across a company. I come across many situations, including the accidental death as well. I know what are the seriousness and other thing and all, how do we pay the regulator and all those things. But many things will be eased out if this code is strictly implemented and compliance is done. Okay, go ahead.
Yeah. So
one question has been asked here. I don't know whether you will be able to answer. I don't have the answer for this. Who is making the HR compliances like Provident Fund ESI of Uber and Ola drivers as on date?
Yeah. See, these will come under platform workers, platform, Ola and Uber. So as far as compliance relating to HR, you are saying?
First of all, I really do not know. When you are talking about the Uber and Ola, my experience with the people to whom we are traveling, they are all not working as a full-time employees.
Yes.
They are working as sort of a, assignment or on call or per trip, etc. and other thing and all. That is what I understand. They are being paid whatever the number of trips they complete based on that. So to say assignment basis or something like that. When they are not the full-time or whole-time employee of the company, I doubt whether the Provident Fund ESI compliances is there or not. That is why I said I don't have the answer.
Yeah, actually, this point is covered under the Social Security Code, and there are different definitions provided for these, like gig workers and platform workers, and there are certain chapters to it. So that chapter describe all the legal provisions about these.
Okay. So that means when you are discussing the next code, you will get the
It is
answer.
not in OSH, it is in
Okay.
Social Security.
Okay.
Okay,
Yeah.
so that we will discuss. Now, I just want to start the Social Security 2020. And again, we will discuss first the objectives, so, because there are so many important acts which will be subsumed by this Social Security Code. So it's provide for registration and a cancellation of establishment. So you can register and then you can apply for cancellation of registration if you want to close down certain things. Then Social Security organization. This is very important, like different organizations will be set up by the government. So this chapter totally government has to do the things here. These are mentioned in this chapter. Then Employees Provident Fund. This is the chapter. Then Employees State Insurance Fund, another chapter. So as you can see that earlier, these are the separate acts. Now, these separate acts are incorporated into this code as a chapter, separate chapter. So Employees Provident Fund, Employees State Insurance Fund, then payment of gratuity, payment of maternity benefit, employees compensation, then levy and collection of cess in case of certain types of work like building and construction. Then you can see that Social Security for unorganized worker. So this is the chapter which talks about unorganized worker, how you will provide the Social Security to these unorganized worker. Gig worker. Gig workers is just like a freelancer. You may see that there are so many freelancers doing certain things. They are not employee. They have given certain job and they are doing. So gig workers and the platform workers like Ola, Uber, these are the platform workers. So
I have one small question or rather doubt.
Yeah.
That today's labor laws, we do not have something like a social security as such, but we have the social security benefits, if I put it correctly. Because when we are talking about the social security benefits today, whatever the labor laws today, which is prevailing, we are talking about, maternity benefit, we are talking about sickness benefit, we are talking about partially impaired, we are talking about the fully impaired, etc., and other things and all. Okay, that is sickness benefit. Those are all the things which are actually built in and connected with the respective act, etc., and other thing and all. There is actually separately act is there for Workmen Compensation Act, Maternity Act, etc., and other things are there. Now, when you are actually talking about the Social Security Code, as they have said it, these are all the acts which should have been actually combined. But today, these are all actually available only for the organized sector.
Yes.
So when you are saying the Social Security, my question is, if it is covered in the unorganized sector, which means the people who are not employed, or who are employed, who are lost their job, etc., how the methodology is going to be there, whether it is covering both the methodology, do you have any idea? That is the
what I have understood, you are asking like how these unorganized workers will get benefited out of this act, right?
Yeah, that's right.
So, sir, I just want to give my analysis here that this chapter, this is Social Security for unorganized worker, gig worker, and platform worker. There will be certain schemes which will be introduced, floated by the government later on.
Okay.
And this is not like you are booking Ola and you have to comply certain things. It is just like government will ensure certain things, certain benefits should be provided to unorganized worker, gig worker, and platform worker. So schemes, regulations will come. And we will have to see. Now, as far as the HR compliance, who will take care of HR compliance? There will be certain regulations like Ola Uber case. The platform owner, for example, Ola, will have to comply those regulations which are there for regulating the platform workers. So there will be separate things which will be introduced by the government and they will have to comply that. I think
one question has come. Is it proper compliance appointment of the factory manager and notifying to the authority? I think Suresh Chandra is asking this question. Even if I go back in today's circumstances, what is prevailing? Factory manager is the person who is actually appointed to run the factory and day-to-day who is actually on the spot. But the responsibility still lies in restaurant. The factory is concerned by appointing an occupier who can only be a director, board of director, or otherwise the person who is a managing director, who is in charge, whosoever it is at least a director level who is actually a occupier. So in this particular question, to answer to him, it is not just a factory manager is appointed and the complaints done. It is not so. Because factory manager can take only the day-to-day complaints, but it is ultimately a responsibility of the director who is actually named as the occupier of the factory. I think in the new act also the same provision, occupier provision, is going to continue.
Yeah, sir, here just I would like to add one thing.
Yeah.
As you have rightly mentioned that the director will be treated as occupier, anyone.
Yeah.
And there will be factory manager also.
Yeah, that is right. That is
Yeah.
because see, if you are having multiple manufacturing units, the occupier cannot be present all the time simultaneously.
Yeah.
So he needs to have the factory manager who has to carry on day-to-day job, etc. and other thing and everything and ensure compliance. But the responsibility still lies with the occupier.
Now, as far as liability, how liability will fall on these persons, this is explained in the law. So what the law suggests that if, let's say, director who will be treated as occupier, he has appointed a manager, factory manager, and there is some accident or something went wrong, then both will be liable. First of all, both. That is the factory manager, if he's there, he is charged with that duty and he is directly liable for that. And along with that, the director, that is the occupier, will also be liable. Now here there are certain defenses are provided to occupier if he proves that enough he has taken due diligence or certain actions he have taken in time to avoid such type of contravention, then he may escape the duty, but he will have to prove that. Are you getting my point? So in general, initial level, both these persons will be equally held liable and will be prosecuted if there is a contravention in factory.
Well, one question is coming, whether any injury, loss of life caused due to natural disaster, like flooding, earthquake, etc., whose responsibility?
See, again, this is an interpretational question, law interpretational. Suppose there is some flooding or something, and you have not taken proper care to protect your unit or something like that, then you will be responsible if anything goes wrong. If you have taken proper care to mitigate certain such happenings or avoid such things, you have taken due diligence about these, then you may escape from the liability. Are you getting point? So you cannot say that there is a flood, whether you had taken all the precautions to avoid any mishappening from this flood or not. You have to prove that to avoid the penalties. Especially in case of mine, they have elaborately described this point. In case of mine, there are chances of flooding, and you have to take precautions that it should not enter into the mines. Okay. I think answer is there, or you want anything in this? Is it clear to person? Like the person?
Shantanu, I have one question. Whenever these kind of events happen in the factories, what will be the responsibility of the company secretary as a compliance officer, and how he has to insulate himself from that liability?
Yeah. So very good question. As far as now we are moving to company secretaries. Now, in case of a company, default done by a company is an artificial person. Suppose the employer is a company. Now, in case of a company, the law suggests that all the persons like director, manager, company secretary, including company secretary, who are, who have not taken due diligence, or they were negligent, or this contravention has taken place because of their, mutual convenience or consent, then the company secretary will be liable. Now, the very important point here, as we had already discussed in our earlier webinar, negligence word is used here, negligence by these people. Now, suppose we are just taking one hypothetical scene here. There is one owner of the factory. He has set up factory. Now he has appointed a company secretary. Owner means the company is company form. Company is the owner, and there is a company secretary appointed by the company. Now the top management is totally unaware of these labor law, for example, and they are just going through the production, right? Nobody is there to explain this provision to the management to how to comply. Now, if there is a company secretary will be it will be treated as the negligence by of company secretary, and if there is a contravention, then he will be liable. I mean, if it goes in a court, if it goes into the court, then I can I mean, everything is clear in the law that this person will be liable, held liable. You cannot expect all other people who are technical people like engineers to comply all this. You are a legal person and legal background, and you have to make sure that these compliances should be done by the company if you are a company secretary in the company. This is very clear. There is no doubt.
Shantanu, one more question. Say, I am sure that even after we are what's called as getting into the courts from the industrial and labor laws, I am sure the concept of the occupier is continuing, or it is going to be withdrawn.
No, occupier will be there, and there will be additional the manager. Both will be equally liable.
Now my question, Shantanu, is whenever these kind of calamities happen or non-compliances happen, whether occupier who is a director will be held responsible, or a company secretary will also be held responsible, or company secretary only will be held responsible?
Yeah, very nice question. See, for this, we have to see the case first, the case-to-case basis. If company secretary was there, he has explained, he has given, let's say, presentation for safer side. Company secretary went to the board meeting and he has given a proper presentation about the compliance of this. He moved out. Now it is up to the directors to comply these provisions, to make sure these provisions are complied. Let's say something goes wrong. Matter goes to the court. Company secretary can put a defense for his that he has informed the board. In that case, company secretary, I mean, he will not be held responsible because he has done his duty. He has done his job. Now, directors, if they fail to address such situations, then they will be liable. But if they have appointed, let's say director has appointed one factory manager, properly training was done that all these things you have to make sure complied. So here the director may get, he can escape this liability if he proves, he will have to prove that he has taken due diligence, he has taken proper steps to make sure that the law should be complied. So this is basically situation to situation.
One more question, because you yourself is a company secretary.
Yeah.
So now suppose if I am a company secretary who is in practice.
Yeah.
This question, it comes actually several times that company secretaries are how we are concerned with labor laws and this, labor codes and all those things, because there is so much of things are there for us to read, like Companies Act, your security laws and all those things. I am sure that very few company secretaries focus upon these kind of issues. with all due regards, because of the constraint of time, constraint of whatever the issues may be. What is your advice to fraternity, to buy that? I mean, what is the scope also at the same point of time? What is the scope for the budding company secretaries in this particular area? Because you are a company secretary, according to me, you are the right person to advise us.
Yes, sir. Surely, what my understanding, what I have seen over the last 20 years as a company secretary, our community, and I have compared our community with other communities like chartered accountants also. And what I have seen that whenever I have seen the era when the secretarial audit was not there. Before secretarial audit, what was the scene? Once the secretarial audit came into picture, there was so much of legal compliance requirements and demand for company secretaries. After MCA portal, it was, kept on increasing the requirement of company secretary. Now, as far as labor law, see, company secretaries should have to think beyond certain things, because it is a new era, 21st century. Legal compliance, when you see so many sophisticated tools you will get, like as you can see now, you need not to go to the ROC to file a return. 20 years back was the situation like that. You have to stay in the line queue. Now everything you can do, like you can expand your business because tools are available. So if any person comes with any company comes, you can offer at least these services also. We can make sure that the labor audit will be done, labor law audit, so that everything will be done. So this is additional services you can provide. It is a totally mental setting, you can say, how you see yourself, how you want to get promoted, or you can want to capture the market. It all depends on individual to individual. But my feeling is that Haryana state, they have issued notification of labor law audit. Now, if labor law audit is done by a company secretary in Haryana, then the government will not send any inspector there for inspections. So this is the initial thing which is already done by the Haryana state government. Now, since this law is basically both the powers, there are state government and central both have powers. We may see in future, because of the sophistication and government may not have so many resources, how many inspectors they will employ. So ultimately, government may come up with such voluntary audits done by company secretaries. If company secretaries are vigilant about it, they are aware of it, definitely there is a good scope for company secretaries, because it is purely law, and company secretary is legal background wala person hai. So the company secretary should show some interest in this, because it is right now you may see that it is a labor law past ka experience aapka hai. Oh, it is very complicated. Now everything will be digitalized. Try to understand, just like MCA and MCA portal. So it will be very easy for you to use certain tools and comply these laws for the company, and expand your businesses.
But Shantanu, in fact, why I'm asking you this question is that whenever I travel to some of the chapters of Institute of Company Secretaries, when I ask them, have you conducted any program on the labor codes? The answer is, sir, nobody comes for that kind of programs.
Sir, what
I said that it is unfortunate, because this is the niche area, according to me, having a lot of scope for the future. And this niche area is to be developed by our company secretaries. My request to you is that wherever you have an opportunity, Shantanu, that please spread this awareness among the fraternity. By this is a niche area, we can develop it, and we are the right people for this particular purpose. In fact, 86 participants are there today at this point of time. I know that what kind of strength this particular subject has, and the company secretaries are the right people. Only thing is, we need to develop this, and we need to expand our knowledge as far as this area is concerned.
Sir,
your views, please.
Sir, you are a very senior person. You have worked at very highest level. You know everything. Basically, the problems, where the problem lies is new company secretaries, those who are not, aware of all these things. Secondly, their mentality is that they just want to go for a listed company, and listed company means there is a what you can company law or security law, just they have to get the package. So this will not develop the profession, I'm telling you. This, you will survive, you will earn your bread and butter. What about the profession? You should take some responsibility to develop this profession. In years to come, it should the people should come to company secretary, practicing company secretary, rather than to going to chartered accountant or some other people. So this is what I can say. And because so many years I have spent here, so I sincerely feels that people like you also, when you say something, thousands of people follow you. I have seen on LinkedIn also, like your statements, when comes so many people, follow you. So basically, sir, as a company secretary, definitely what I can spread the awareness to the maximum possible extent. But people like you who have so much of experience, and people like you, reputation, if you say anything like that now, so it will help to the profession. Like the junior people, I mean junior, those who have just joined, they should think about it, and they will learn about it, and they will, what I feel.
And for that reason only, we had this labor law series from Mehta and Mehta. Because I think the only CS firm which had labor law regulations presentation.
Yes. Because this is the need of the hour, and there are many people who are still sleeping. In fact, I had discussion with 2 company secretaries. I will not name those company secretaries of my level. One person I asked, are you aware of labor laws are coming, new labor codes? She said, no, I'm not aware. She is a company secretary, by the way, of a very good company. Second, I will not name. Another person I asked, he is from IT, whether are you, kisko padi hai, kon bas apna kaam karo, ghar jao. This is the mentality, how the profession will develop. I just wonder sometimes how profession will. Now, what I feel, the case we had discussed, it is the Supreme Court. If any judgment comes from the Supreme Court, as we had discussed, the company secretary failed to deliver what he was expecting, it was expected from him. And if Supreme Court penalizes or punishes any company secretary in such cases because of the negligence, I think the people, all the company secretaries will wake up to that. I mean, this is what I feel. This will teach a lesson to all people. Otherwise,
Shantanu, definitely, I will spread the awareness wherever I can, and definitely, and I'm also going to suggest your name as a faculty, because I don't know any other faculty who can have this thing, because you are having the dual and deadly combination of a company secretary having expertise in this labor codes. So wherever and whenever, if anybody asks me, certainly I'm going to refer your name so that you can spread the awareness among the fraternity.
Yes, thank you so much, sir. And I will always be ready for this, because I am, I can say that I'm dedicating myself for this cause, because life you get once, and you should give your best to this world. That is what I feel. And this is the area of what I feel that people should see this as a huge opportunity. Like company secretary should see this, and that is the reason I'm working on this.
Actually, at Mehta and Mehta, we were following labor law since more than a decade, and we were doing due diligence and consultancy over the decade. And when this new labor law and all that is coming, I thought it was going to be big change. And that's why we specifically thought that this should be the part of webinar. Honestly speaking, when he told that this being a out of scope kind of thing, you will get less participant and who will attend, I said, whatever may be, but whosoever attend, it will be enlightened, and we should have, this is a very important legislation and very important part of the organization. As a CS, we should know that, and that's why we started this. And of course, your knowledge helped us. Thank you.
Let us listen from Jambunathan. He raised his hand. Yes, Mr. Jambunathan.
Yeah. So no, it's a very valid question. So I share my gray hair of being both a company secretary and a chartered accountant. I've never been so much of a practicing company secretary, but a corporate. I think we just get qualified to take the platform. We need to have the attitude and the initiative towards business to survive. We can only survive and grow if we go beyond the returns and the what we have in the as a corporate secretary. So I would say that I had the opportunity, by God's blessing, even to run business and businesses of Mr. Sudhakar will know much better. In Reliance, if there is a turnaround, 3,000 people from our company will be there. Like that, all over India, whichever petrochemical, chemical industry, our people. So it is our job to understand what is safety. The operation people have enough risk materials to do it, observation, root cause analysis, near misses, minor accidents. So it is important for us to get involved, not to understand, but also to protect us and the board in order to have the right presentation and the data during the time of board meeting or during the management information meetings that we have. That definitely helps. What Shantanu said, when there is a notice from the dish people, even after paying for compensation for disablement, there will still be notices to occupier and manager. And that time, these documents which goes through, safety walks or whatever we have, this will help. And there we have to go beyond our Companies Act and things like that. And that comes only for either by blood or by attitude or by initiative, but step beyond your office in order to survive in today's world is my input in this situation.
Yeah,
I would like to just take a few minutes. I am going back to 20 years back. We used to have those days, what you call the license Raj. Suddenly things are opening up. We had about 5 manufacturing units. One of the manufacturing units, which is situated at Pondicherry in the coastal area, we wanted to actually carry out the painting job. The factory ceiling is around 30-35 feet height. Then immediately we have constituted a committee where I was also a part of the committee. Because people told you are the right person to tell us what are the various compliances, what are the precautions, what are the do's and don'ts we have to take care when you are doing this big job. So they decided to appoint the lights people as a contractor for the painting. I, along with the team, spent almost more than a week, listed down item by item the checklist, what are the things which are to be taken, what is our job responsibility, what is the contractor responsibility, what lights will do, what we will do, what is the things, etc. And one of the things I said was, because this area is situated something outskirts of the city, no medical facility, etc. is available. I told one vehicle should be there, spare with the driver, throughout this period of the contract gets over. If anything happens, goes wrong, we should be able to take immediately to the hospital, etc. and all this. People debated and discussed on the cost wise. Unnecessarily vehicle will be standing, we will pay. Forget about it. Compliance is important. But we have to prepare for any, emergencies, etc. Then ultimately everything is done. Touch wood, everything went on well to the extent of 98%. Job is completed totally. But the last day, some minor touch-up was to be done. Contract fellows have come. The fellow has to actually claim over, he has to do some certain cleaning. That's all. We have to wear that safety belt and safety jacket and a hook and other things and all this. In spite of insisting, telling and other things and all, that fellow who was doing the job, he did not listen. And he even, not listening to the supervisor of the party, he climbed over, he started cleaning. Unfortunately, he fell down, he died. It's a small place. It has become a big chaos, newspaper, this, that, etc. People are taken to the custody and all the things have happened. And when we went actually, as you rightly said here, Shantanu puts it here, who are the people? First thing is the people who are constituted the committee. All these committee people were there. I was also one of them. Then they started examining in detail. After going through the thorough checklist, they are actually convinced we have done our basic job. Then they started implementing the issue one by one. When they started going one by one, etc., ultimately it came down to the Lloyd's people, and they called. Some other Lloyd people took it very lightly. Somehow they did not spend, they sent the junior person and other thing, and all the people got very annoyed. And ultimately, the end, what has happened was we have been called not only a labor commissioner, but also the industrial minister. That was the last appointment which we had, and the judgment has come from them, the order. There they said, we are taking the action against the Lloyd's fellow, not ensuring this, not strictly implementing it, putting the people, etc., and other things and all. Second thing, as far the company is concerned, you have taken all the precautions, you have listed down everything, but you missed out something. That came out. I was breaking my head. I had gone through threadbare. What I missed out, I really didn't understand. Nobody could make it out. Then finally we asked him, sorry, sir, we have gone section by section, requirement by requirement, mandatory, everything we have done. What we have missed out? I think when you are saying, definitely there is something, please tell us. You know what came out? They said, there is a recommendatory requirement of putting a safety net at 10 feet above the ground level. If something goes wrong, that you missed out, not putting the safety net. Then we saw it was correct actually. That was a failure he pointed out. He said, although it is not made mandatory, it has been recommended, but you have not done that. That is what it has happened. Finally, the action was taken against the contractor, but the company, because of all these things, our unions is what you have done. They have actually levied warning letter with a 1,000 rupees penalty 20 years back. So as you rightly say, it is the company secretary has to take a lead and he has to come out. In fact, CGRT has brought out the nice book on labor laws and practicing areas available. Even the institute is also brought out. But Sudhakar may be knowing, all our fraternity people, we are some other thinking that our core area is only company side, core area is only listing agreement, core area is only security laws. That is what we think. Even finance also, we don't look at. We think it is not our job. That is the thing. That thinking has to change.
It must
see, Bala sir, the only thing is, what is the reason for that? Over a period of time, it so happened that unfortunately or fortunately, that kind of awareness is not being created among the, especially the budding professionals. In fact, when you ask them, say, for example, I interact with the students more because of the CLDP sessions or MSOP sessions whenever I take. So about last week, at the Center of Excellence at Hyderabad, I have met some of the students, while addressing the CLDP. So coincidentally, I asked, that's why I'm asking so many questions to Shantanu now. I asked them whether they are aware of this new labor codes which are coming. They have no idea at all. And this, and then again, I asked them that, are you interested in starting the practice in labor laws? They said, is there any scope? Now, who will tell them whether the scope is there or not there? I am certainly going to, whenever I interact with the council members of ICSI, I am also going to bring it to their notice in my own way. But it is the responsibility of the senior members to create this kind of an awareness among the youngsters, especially. But you have to study finance, what's called as, you cannot confine yourself to the company law and security laws only. You have to spread your awareness. But yes, no doubt about it, you don't need to have the expertise in everything, but you should have the awareness of everything. Yes, Shantanu, yeah.
Just one point, what you have said, just few days back, one chartered accountant, can you imagine, chartered accountant is too far from law. One chartered accountant, he's practicing in Surat, I will not disclose the name, but he called me because he has seen my lectures and all these. And he is practicing in GST right now and accounting and normal stuff. And he is asking me, sir, I would like to, develop practice here in this labor law compliance also. Like, he is a chartered accountant. Try to understand this. He is a chartered accountant. He want to venture into this. And the company secretaries, they are not aware about labor law. Now, another thing which I would like to emphasize now here, see, abhi tak jo labor law tha, it was Inspector Raj or use of paperwork. Even if a complaint was filed, nothing will happen. Now it is totally digitalized. Even as one single employee file a complaint, there will be a proper tracking of that complaint, and ultimately employer and through employer I mean the company secretary will have to respond to those notices, because this time it will be digitalized, very easy for, and the public is also getting aware now. It is not like that earlier. People are aware now these things, these are the rights of the employees and they can utilize those rights. And if they file complaint, ultimately the company secretary will have to study this labor law to respond. It is better to study ahead of such things so that you can prevent all these occurrences. So
in fact, Shantanu, I am not aware of whether in the CLDP or MSOP of ICSI, whether labor codes are there as a subject or not. If it is not there, certainly I will put my best of efforts to
Sudhakar,
get
it is
into
not
at
there.
least pardon, sir?
It is not there.
It is not
We
there.
are only,
Okay.
we are only talking about the corporate laws. We are talking about the leadership. We are talking about the corporate governance. We are talking about various other things. It is not there.
So certainly, let us, wherever possible, let us put our best of the best efforts, and wherever I have an opportunity, certainly I will try to push this labor codes in the company secretary's arena also. I think this is the high time for that, and I'm going to put my best efforts, at least as far as this is concerned.
It will be great thing, sir, if you take such actions or you recommend to the institute at least for this, because I have been teaching CS students also for so many years. What I've seen earlier, we were having a chapter, separate paper for labor laws in the intermediate stage, that is executive stage, and later on it was removed. And only little bit of labor law compliance was there. And in final, it was made optional. It was made optional paper. I think this is the labor law is applicable everywhere, even in the industry. If there is an industry, I mean, there is not a company, there may be some partnership or some individual proprietary. There will labor law will be applicable to those places also. It has wide applicability as compared to company law. And I'm sure it will be applicable to each and every establishment wherever you go as a company secretary. So definitely the knowledge of this law is very, very essential, and especially now, because now there is a total labor reforms. 100-year-old labor laws are being, subsumed by new labor code, and this is 21st century code. Everything will be, on track. Complaints and notices will be issued just like we have seen in MC also. So I think it should be intermediate. In intermediate, there should be one paper of labor codes. At least 70 marks should be given to this.
Yeah, I think Shantanu, I think Vaibhav is informing us that already, as far as the course, the curriculum of company secretaries are concerned, it is already covered. The labor laws are covered there. Even not only now, even when I was doing my company secretaryship way back in 82, 83, that point of time, we have an exclusive labor laws. Virtually about 26 labor laws were there as a part of my course curriculum. No doubt about it. I'm aware of that.
You are right, absolutely. Even today it is there. Even today it is there. We study actually in the course, but as you rightly say, some or other, from examination point of it is not there. Seminar and other thing, it is not happening as awareness is not spreading through. That is true.
I'm not sure about latest syllabus. Actually, in 2017 syllabus, I have seen that it was made optional in the final, and very small portion in the intermediate. It was just like nothing. So in the latest syllabus, I haven't checked because I'm not teaching company secretary students right now. So I will have to see if it is incorporated. It is a really nice thing. It is
in fact, Rakesh is informing that NIRC has organized a master class on labor codes. This is welcome feature. This kind of things, more programs should be there.
Yeah.
So that this area also can be developed as a niche area for company secretaries.
And at least at every chapter level, the program should be held, what I feel, chapter level. So that
I appreciate Shantanu.
Yeah. So this is what we have seen till now. If whether we should proceed or what exactly what we have to.
Can I suggest something?
Yeah,
Please.
Bala?
yes,
See,
please, yes.
Yeah, see, I am also practicing chartered accountant, but also member of our CS Institute. What I feel that this specialized subject like labor laws, etc., institute means ICSI can conduct certain courses and give a certificate that you which will be in detail rather than 17 marks, 20 marks. That could be there just as an introduction to labor law. So people will get a flair as to what some of the compliance required. Now, having done CS, if somebody wants to get specialized into this, then in detail some code should be available and certificate should be avoided, so that he can also write, okay, I have done, like in CA there is a CISA, etc. you have done, no? Or there are courses on international taxation, so you have expertise later on into that course. So something like this will definitely help, because then if it is done specialized means it will be covered very much in detail. That's my suggestion. Thank you.
It's really a welcome suggestion. Actually, we can put it out to the ICSA. I think Sudhakar, you will be the right person. You can take it out sometime. Anyway, you are taking it out. Something like certification course or something like that.
No, it is there. It is there, Bala. It is already, see, certificate courses are already, crash course is already there. In fact, one of the participants is mentioning that he is a chartered accountant, company secretary, and of 78-year-old, and he has completed the crash course exam on labor laws. I'm aware of the crash courses are there. See, that what I was trying to drive the point is only that in the chapters which are small, there the scope, because whenever I travel to these places, the company secretaries come and say the scope is not there for us in practice here. So one of the areas, the niche areas which we can develop is this particular area. Because say, for example, just like GST, there are several company secretaries in small towns. They are taking up the GST as a niche area. They're having some kind of a work there. I'm sure that these places like, Surat, Bhilwara, Udaipur, and all these places, these are all industrial hubs. And there, the company secretaries can definitely have the scope of taking up this labor codes. And I'm sure that the industrialists will give more weightage to a qualified company secretary than of others to give this kind of an area. But only thing is, our fraternity has to develop the expertise and to develop a taste to handle this kind of a profession. For that, definitely what we need to do is proper advocacy is required, proper awareness is to be created. That's what I was trying to say.
Shantanu, some
But as Dipti rightly was mentioning that, in fact, I have not seen anyone organizing webinars. In fact, after my association with Mehta and Mehta, this is the only forum where I could see that webinars are conducted. But I haven't seen. Might be it is not like that. Nobody is doing that. But this is the first time, in fact, I am actually seeing that this kind of webinars in a private forum, not at the institute level.
Long back, it was being done in a CCGRT, but some other things have changed. It is not happening now. That is the thing. Okay, let us look into this. Labor authorities insist governing under the CLRA the software vendors such as TCS, Infosys, IBM, etc., who are engaged by a company. What is the correct position under the existing and proposed law?
Sir, can you just repeat? I couldn't hear the initial.
Labor authorities insist on covering under CLRA the software vendors such as TCS, Infosys, IBM, etc. So we are asking who are engaged in a company. What is the correct position under the existing and the proposed law? I think he is asking in respect of the what you call contract laborers. Because TCS, Infosys, IBM, these people are all likely engaged with the vendors for render the software services by a company.
If they are falling under the definition of contract labor, first of all, then they will have to comply. There is no escape for them.
Because that is what he is saying. When he says CLRA, I can make it out. He is talking about the Contract Labor Regulations Abolition Act. That is what he is talking about.
Yes, yes, CLRA.
So you know to get it registered.
Yeah, existing you are talking about. Existing, I may not be able to give the clear picture because existing, I think the limit is something 20 or something like that.
Yeah.
But here in upcoming new labor code, the limit is 50 contract labor. Now,
Okay.
when you talk about contract labor, please remember that you have to identify whether it is a contract labor or not. There may be some gig workers also. So gig workers will not be treated as contract labor. Okay. So I'm not sure whether you have figured out that these are contract labor, and if it is like that, 50 is the limit. If they cross or touches the 50, then they will have to go for license and all these thing compliances, even in such Infosys and like that.
Differences
Shantanu sir,
are-
if I clarify, here what is happening that this is a principal to principal contract. So now TCS is engaged, like MCA is engaging TCS Infosys, like every company engages these software vendors. So these software vendors, depute their professionals in our premises to develop the software and maintain that. So principally it is a contract for service, which is a principal to principal contract. Now, we are not regulating, we are not paying anything directly to their staff who are working. So it's a man hours based time and material contract with TCS, and TCS deputes its personnel here. Now, some labor authorities say that, since they are operating from your premises, they are contract labor, you should obtain the license, and they should, do the registration and all those compliances to be made.
Good.
But the position, if you read the Basanta Mohanty case, and, Odisha High Court has held that contract for service will not be covered under the CLRA. So whereas those positions are actually not taken as such by the Maharashtra authorities. So I just wanted whether you have come across any such situation. What are your views on that?
Yeah, this is very typical case, and it requires a lot of legal interpretation of these terms. And as you already mentioned the name of a proposed case law, and you also correctly mentioned if there is a contract for service, then it will not be a contract labor. So we have to see the particular case and whether it will fall under contract of service or contract for service. First, we have to analyze those things in the given circumstances, and then only we will be able to see actual position. Because see, one thing is also very clear, that government authority will always try to say that no, it will fall under this and you have to comply. It is our responsibility, our duty is to check whether actually it will fall under contract labor and whether company will have to comply. We have to check from all the angles. So right now, we have to see the case in detail. It is not like just you have asked me and I can answer like that. We have to see each and every aspect of that contract, how the things are being delivered. Then only we will be able to come to know about the legal position, what exactly it will be.
Maybe, sir,
So
can we apparently say that if it is under the supervision and control of the employer, so the contract labor is applicable? Can we say that in that perspective?
Yeah, basically, sir, when we say contract of service, it is like a relationship of employer-employee establishes whenever we say contract of service. So he will be under the total supervision control of the employer. Then definitely it will be more close to, to comply these laws relating to contract labor. But if it is not like contract of service, then definitely just like a consultant or something like a person-to-person contract is there, that you sell these things. So if there is no control of contract employer, then it will be contract for service.
No, again, like Shantanu puts it correctly, the arrangement will definitely to be looked into. Because
Yes,
I also seen in a lot of IT companies, what is happening, as you rightly say, the other companies, people come and sit in the premises of this IT company, they do the job. But really speaking, these people report to whom, take instruction from whom, are the person in the premises where sitting, are they actually getting the things done through them? What is the thing? Or they are listening to the people to whom the contract is given. What is the terms? Those are all will matter actually. Unless until that is examined and see the things, I don't think the right answer can be given.
One example, just by sitting a person in the establishment cannot be treated as an employee. For example, if a chartered accountant who is an auditor or statutory auditor of a company, and he sends some articles there regularly, and they are sitting there and they are working. You cannot say that these articles are the employee of company or like that. So just merely a person is working, sitting there and working will not make him as an employee or contract labor. That is for sure. You have to see the details.
Yeah. Generally, these regulatory authority like inspector who file criminal cases against the company, they take all name of the board of directors, including the chairman and the company, and how they justify. That is one. Just a prominent name, they want to be in the limelight. He is no direct connect to such offenses.
Yeah. See, basically, what the law suggests, if there are some certain board of directors, there, let's say there are 5 people on the board, the board should fix one person with this responsibility. For example, out of 5 directors, 1 person has been held responsible as an occupier for looking after that factory. Then in that case, they will get discharged, other directors, if one director is specifically mentioned to look after the compliance. Again, that director will also appoint somebody in the as a manager in the factory also, then both will be jointly responsible. So as you mentioned, sir, it is their choice that they can name all the directors. Okay. You cannot stop them at the
correct. That is what normally happens. Even in MCA also, if you actually look at it, they just go by whatever the names are appearing in the MCA portal. They send notices irrespective of executive director, non-executive director, independent director, everybody.
Yeah.
Then ultimately we have to go and tell them who's actually executive, who's non-executive, who's a thing. The things can be sorted out later, but we cannot stop them actually.
We cannot stop because company, when there is a company, the director and the person, third party can always name all the directors along with the company. And now it is up to you or your lawyer or something. You have to prove that these names should be taken away, removed, and only the person who has been charged with this duty will be there. So court will take care of that.
One more thing is there, if nobody is actually named, then the entire board of directors will be responsible as per the law.
That is by default, it is the position. Like if you don't take any person held responsible, make any person, then all the directors will be responsible.
Correct.
Even in case of partnership, all the partners will be responsible. The partner is just like a director in this case.
If the company engages a car hire agency to hire car with the drivers for the senior management personnel, whether those drivers will get covered under CLRA or what are the compliances obligations of the company?
Very nice question. Again, we have to go into the details of the service contract. Like if it is like Ola and Uber, it may not come, but if you are specifically engaging certain, it is like one person who is providing this type of services. Okay, pick up and drop. And
yeah, if the car hire agency is employed and if the agency is running a service, if the drivers are actually with them, the job is only to pick up and drop the people, so to say. Then as Shantanu puts it, it is the responsibility of the car hire agency to take care of the compliances. That is the thing. As far as the company is concerned, so long as they are coming inside the factory, getting out of the factory, those safety requirement, etc. and other thing and all, they have to ensure there. That is what I think so in these cases. But again, here what happens is if you are engaging a car hire agencies, I don't know whether that limit of 50 will be covered or not.
It will come to the basic agreement. We have to check the agreement. For example, there is a car renting or something service one person is providing. Let's say he has given 50 drivers, 50, directly coming to the 50 mark, 50 drivers to the establishment. And these drivers, the duty is that they will serve the people in the establishment. Now you can say that these are under the control or supervision of employer. Employer is instructing drop this person there and that. So it may be covered as a contract labor. and finally you have to comply. So again, whole thing, you have to see the agreement for this purpose. If they are just coming and dropping something like that, and they are doing rest of the work somewhere else, they may not come under the contract labor. It is totally depend on the kind of agreement you are doing.
There is a trend that the entire operation and management of the factory is outsourced to the OEM. Such a scenario, what will be the role of the occupier?
Occupier cannot escape his responsibility. He cannot escape his liability, but just outsourcing these compliances to any person. As we have already discussed that although he outsourced, still he will have to make sure that everything is going smoothly. And if there is any negligence on the part of the occupier, first of all, he will have to prove. He will have to prove that he is not guilty. So by default, he will be guilty, and then he will have to prove that I'm not guilty because I have appointed so and so person. I have taken all the cares and like this due diligence we have taken. Then only he will be able to escape from the liability.
Suresh Chandra is actually providing information for us. A company secretary having a ACS, FCS membership can appear as an advocate before the labor court. I mean, any requirement to be member of the bar council.
What I have seen till now, I'm not just giving 100% correct answer, but what I have observed here is no need to have a bar council membership for appearing before the authorities here. So you need to have authorization from the company or the employees to represent his case as of now. And there is a particular section which governs this authorization by employee, authorization by employer. For example, if there is an employer and he is association of any employers association, then the officers of those organization to whom this employer belongs can present his case into the in front of authorities. This is what the picture is like that. So
the message is already posted here. Sudhakar has also read out. It is a question of taking the interest of oneself with the changes. I am a CS and I am 78, but I still study. Yesterday, I passed the examination of crash course of the labor laws. Great job. I congratulate you, sir. Hats up to you. I think it is an interest. I definitely hats up to you very much. It is a continuous learning process. You are really an inspiration.
Yes, sir. True inspiration.
I am a company secretary and presently practicing an advocate. I have recently carried out legal compliance audit and a power manufacturing company and prepared the compliance checklist for over 80 laws, including the labor laws. Great job. I must appreciate.
Nice to know that.
Is casual labor defined in the Act?
Casual.
Yeah.
Casual word has been used. I'm not 100% sure right now. The casual labor has been defined, but I will come up with that clarification later on. But yes, it is used.
Sir, why can't we have the statutory form for occupier and the factory manager who is responsible for all labor law compliances like we do in the CS to be lined in the MCA or other regulations? I'll tell you one thing. In fact, you see, it is my experience because I'm a little old timer. But the thing is, the company where I was actually working, every board meeting, we used to place meticulously 3 compliances certificate to the board members. One is under the Factories Act. In fact, the compliance in the Factories Act actually addresses various things, like all the labor law compliances have been done, all the payments have been done, all the returns have been done, all the risk is being addressed, and all the safety norms are actually adhered, or the safety health policy is actually adhered. Not only that, we used to conduct the what we call the fire drill, mock fire drill to people. That is there. That is scheduled periodically. It is done. Different things of using, there will be many fire extinguishers will be put in the factories. I do not know how many people will really know how to use it. We used to conduct those drills. We have a schedule. Whether those drills have been conducted or not conducted, if not conducted, what is the reason? when it will be conducted. These sort of the compliances used to be given by the occupier of the factory to the board. That is one compliance certificate which we used to give. Second compliance certificate used to be given in respect of all the secretarial compliances and also the LODR regulation, which is as a company secretary, I used to give. And the third compliances is given in respect of all the other applicable laws. Just now we saw some 80 laws he has prevented the compliance will. Why is that? In the company where I was working, 95 laws were applicable to the company. We cannot name all the 95 laws. We used to only name the exceptions where the delay has happened, where the compliance is not done, what is the action being taken. Like that, we used to actually put up this. This is actually part of the thing. If anybody is interested, I still will have somewhere the form which I can actually share with it what we used to put on the factory compliance. Labor code having the clarity on the beneficiary should comply with the correct labor aggregator and platform provided, but current laws are silent on that. I agree with you because the new laws is actually an improved version of the current laws which is actually coming, covering organized and unorganized sector both. If I am applying a contract labor as a consultant, retainer, then I need not to do any compliances. What is that? Any compliances? People uses the windows as on date. I'm not very clear here. When you talk about the consultant and the retainer, I'm confused with the contract labor actually, because consultancy is the different thing. Employing the contract labor something different. Can you speak out, please?
Yeah, Balaji. See what happened actually, like as on date, if I am appointing any consultant or retainer, in that case, I need not to follow that HR compliances. So people are, as a manpower agencies are also doing the same things. If they want to hire, contract laborers, they will rename it as a retainer or as a consultant, and then prepare agreement in such a way so that to escape this, that HR compliances that has been not following by that all manpower agency. In fact,
Tushar, I'll tell you one thing. Sorry to interfere in between. Sorry. If you are outsourcing your HR function or even the payroll function to somebody, whatever the name you call it consultancy, you call it retainer, you call it whatever the name you call it, the basic responsibility of the making the payment and ensuring the deduction and depositing the money in the government and filing the returns still rest as the employee on your part. Whatever may be the your agreement and compliance, etc., you cannot accept the compliance. Because just because I give the HR outsource, I don't have to do the compliance, you cannot escape it, because the basic responsibility of the people working under your organization, though you outsource, your responsibility still lies. Making the payment in time, making the deduction in time, deducting the salary in time, depositing the money in time, entering the provident fund, etc.
Bala sir, just like
I think
for many corporate contributions, we generally engage big fours. For example, they have a big background and people employment there. And on specific domain purpose, we are going for taking their services on random basis or regular basis. If this is the case, then they will fall under the Contract Labor Act. You mean?
Contract labor, I think what you are saying, there is a confusion. Like
yes, sir.
PwC, you are outsourcing the labor law compliance to PwC people, and they are complying. PwC means Big Four, and they are complying, and you will not be responsible for that. This is the question, or it is something like if they are complying, their employees will be a contract labor for your organization.
See, instead of, for example, I have say like any tax team or say like a HR team, these are having a domain and they are ready to do it, and I sign an agreement with them. And this is on shared basis, because if they have not disclosed the name of the people, but yes, they comply whatever I need and they support and guide and advise, and the agreement is like an advisory role.
So this
then
is consultancy.
You think that no, these Big Fours are also required to comply, and we fall the relationship under the Labor Contract Act with
No,
them?
no. It will not fall as what you have described. It will be a outsourcing. It will be a consultancy work, and you have no control over those people. You can just ensure that whether they are complying with the labor law or not, you just have to check. They are the master in their work. You cannot control them. So there is no question of employer and employee relationship or worker relationship. So the contract labor provision will not apply here.
And since the agreement with them is purely with the full clarity, it is an advisory role.
No, contract labor will not come in this picture. That is
Okay,
right.
sir.
What you are saying is correct. I agree with Shantanu says. But you cannot escape the compliance part of it saying they are complying with it. Because you have to ensure they comply. If they don't comply, action will be taken against you, not against them.
Okay.
Just to simplify this aspect, let's say you are the manager of a shop and you have appointed one watchman to take care of the shop. At least you have to make sure that that watchman is doing his job. If he is gone and you are not aware, then you will have to pay the price. I mean, you cannot escape your own responsibility even after employing somebody. You have to make sure that everything is working fine and legal compliance is there. You cannot escape.
Okay.
Please share the contact details of the speaker for the future reference. That can be shared, there's no problem. When these labor law codes are expected to become effective, I don't think I have an answer for that. I don't know, even Shantanu will also have an answer, because as on today, the rules are still under the draft stage. Once the rules are circulated, it is approved, then the law gets passed. You know, there is a procedure because the parliamentary matter, because it has to get approved, it has to get passed, and it has to be notified, then only it will become effective. Till then, the current laws will actually continue.
All the codes have already been passed by the parliament. Only the rules that these rules also have
effective date of implementation. I'm talking.
No, I'm coming to that. Effective date of implementation is total in control of the government, central government right now. And we had discussed last time also. It is up to the government when government wants these to be implemented. Maybe this year, by the end of this year, maybe next year, I don't know. But we have to wait and see.
Corporates who are having agreement with the IT company like Wipro, Infosys, etc. for on-site, off-site support without having the number of people with the support of the share basis, whether this will fall under the contract labor. Again, we talked about this sometime back, because much will depend upon what is the sort of the agreement, what it is, that is what it will happen. Again, the subject to the number, etc. and all those things.
Always remember, sorry to interrupt, always remember one thing will be very important to decide this whether contract labor or not. That is contract of service or contract for service. So it totally depends on the agreement, how you have drafted that. Yes.
These are only certificates are placed before the board, but on the ground reality or things are in place can be corroborated with the independent documentation. See, it is not only a document which is placed. Document is actually the reality. You have to actually see and you have to actually visit. In fact, we used to visit many manufacturing places. We had an experience of conducting the board meeting, the respective manufacturing plants actually. Because we had a 5 manufacturing unit, we used to conduct the meeting in a rotational basis. At time in Calcutta, at time in Jamshedpur, at time in Pondicherry, at time in Jammu Kashmir, like that. All our directors are actually taken on the site. We used to see actually. It is not just a paper creation or something like that. It has to corroborate with the actuality what is there. Rakesh sir, if I can share the draft compliance checklist with us, it will be very beneficial. Okay. If possible to share the checklist, it will be beneficial to your CS community. Can you share presentation by email? Presentation is actually coming along with the recorded things. We have YouTube unit is already put along with the presentation recording. Whole recording will be available. It will be circulated on your registered mail ID. You will get it. I think that's all I have in the question box. Yes, Shantanu.
Yeah, so basically we are left with some little bit of portion, but almost we are approaching 2 hours mark. So the OSH code we have already discussed, and we have discussed the objective of SS code also, Social Security Code, and reporting of vacancies. This is the last objective that if you have certain vacancies in your organization, you have to report it to the authorities so that everybody will be aware of this and people will be able to apply for the job. So just a minute. Now, after this, SS code. Now, as far as applicability of SS code, that is Social Security Code, it is a bit of complicated, means there are different chapters, and applicability of each chapter we have to see. So applicability of SS code, to whom it will be applicable, on whom it will apply, this is given under first schedule of this code. And as we go through the first schedule, it says that chapter 3, that is provident fund provisions, will be applicable where 20 or more employees are working, not below that. Okay. Similarly, employee state insurance provisions, that is chapter number 4, will be applicable if there are 10 or more person employed, except in seasonal. So seasonal establishment will not get covered. If it is a seasonal, then again we have to go into the detail what is seasonal, what is not, but it will that will take away our attention. So it is just, I'm briefing you. Also on hazardous occupation. So if you are involved in any hazardous process, remember this State Insurance Act will be chapter will be applicable even if there is a one employee. So if hazardous process is there, this chapter of employee state insurance will be applicable on your establishment. Plantation people may opt out of this state insurance scheme. Now coming to chapter 5, that is gratuity. Every factory, mine, oil field, plantation, port, railway company, it will be applicable to all. Shops, establishment where 10 or more employees are engaged, and such stop and establishment as notified by appropriate government. So if there is any shop and establishment where 10 employees are there, gratuity will be applicable. But remember that central government or appropriate government may notify certain shops which lesser than 10% employed, still the gratuity provision may be made applicable to such small shops also. It depends on the appropriate government. Now, maternity benefit, that is chapter number 6. Maternity benefit will be applicable to all the establishment which are factory, mine, plantation, including establishment belonging to government, and shops and establishment if there are 10 or more employees, and such shops and establishment as notified by appropriate government. So you can see that even small shops with 10 or more person, this maternity benefit will be applicable. This chapter will be applicable. You have to provide all the benefits to maternity benefit to women. Then comes chapter number 7, employees compensation. If chapter 4 not apply, then this will be applicable. So basically, in any establishment, either state insurance chapter will be applicable, and if state insurance is not applicable, then employee compensation chapter will be applicable to that. And for that purpose, the definition of employee, who will be treated as employee for the purpose of this compensation purpose, it is given under Schedule 2. A very long list of people who will be treated as employee and will be able to claim the compensation. It is given in Schedule 2. Then comes to chapter number 13, Social Security and cess. So the cess will be applicable to establishment which are building and other construction work, which are doing this type of work. They will have to pay cess for the benefit of the workers. Social security for unorganized worker. This is another chapter, number 9. Unorganized sector, unorganized worker, gig worker, and platform worker. So majority of questions which are related to this gig workers and platform worker will be resolved here. And the government, it is government job basically to come up with certain schemes. So we will see later on in this chapter. Then comes another chapter, employment information. It is basically next chapter, 10. Employment information and monitoring, career centers, vacancies, persons seeking services of career center and employ. So there will be a system where you have to report your vacancies to a particular authority, and it will be known to all the people, and they will be able to apply for jobs. So this is all about social security. Now there are so many penalties which are prescribed under section 133 of SS code. So I don't know whether we have enough time, but these are the penalties. So first penalty I just want to cover, whether people are still, everyone is there because it is almost 2 hours now. Being an employer fails to pay any contribution, which
75 people are there even now.
Okay. So being an employer, if you fails to pay any contribution which is liable to pay under this code or rules regulation scheme, then you will be held liable. Try to understand, this is very severe penalty with imprisonment for term which may extend to 3 years. So contribution, when we talk about provident fund contribution, like you are liable, but you are not aware and you are not making the contribution, paying the contribution, you will be held liable, and there may be a jail term of 3 years. So you should be aware. But which shall not be less than 1 year in case failure to pay employee's contribution, which has been deducted by him from the employee's wages, and shall also be liable to fine of 1 lakh. So minimum 1 year imprisonment is there if you have already deducted the employee's contribution from employee's wages and you are not paying. So it is a serious, more serious offense. Then which shall not be less than 2 months, but may extend to 6 months in case other cases, and shall also be liable to fine of 50,000. So these are the penalties, provided that the court may, for any adequate and special reason to be recorded in judgment, impose sentence of imprisonment for lesser term. So these are the penalties. I think there are so many penalties, you have to watch for it. I have made a presentation on all these. I have covered it properly. In this, you can see that I have accumulated all these penalties where there is no imprisonment. And second set will cover where there will be imprisonment also. Okay, so let's say these penalties, you will not, you will be liable to penalty as well as imprisonment. But here you can see that A to Q, what we have seen, only 50,000 rupees of fine is there. So I have bifurcated. We don't have enough time to cover each and every penalty right here. But in the presentation, you will see. Now, coming to the forms, there are important forms. Almost 26 forms are mentioned, and few I have highlighted here. Register of women employees. So this talk, because there is some special features for women. So you have to maintain a register of women employees. Unified annual return. So one combined annual return you have to file, no separate return, just one single unified annual return you have to file. Then form for reporting vacancies to career center, you have to report the vacancies if it is there. Form of EIR, that is employment information return, you also have to file. So these are the forms. Now, there are certain rule number 55 and 58, which talks about maintenance of record and register. So this is, I have given, but since the time is very less, I think this is the last slide. If you permit, I will cover this. Otherwise, we can take questions because already 2 hours have gone and I have to go.
I have only one small clarification I want to ask you.
Yes, sir.
When you talk about the career center and the notifying the vacancies, I think even today, there is a concept of what you call employment exchanges.
Yes, correct.
I do not know how many people in this forum is actually aware of the employment exchanges, because employment exchanges are there throughout all the states, I think, across India. And the people who are actually graduated, they are supposed to go there, get registered themselves. And then, you know, the vacancies are to be notified through the employment stock exchange. You will get a call. That is what the feature which has been there. I think 30 years back, it was working greatly large. After, you know, all this media and other thing and all advancement, external agencies have come. I do not know. I'm not even aware even today whether many people will be aware of the employment exchanges or something like that. Also, when you're talking about this career center, whether these will be converted as a career center or they are thinking of establishing a new career center places or something. What is your opinion?
Actually, it is just like exchanges, career centers, mainly. Government may further define its role later on. Certain rules and regulation may come up later on. But the basic idea is that career center, you have to report the vacancies. For let's say in Pune, if there are so many companies and they are having certain vacancies, then they have to inform these vacancies to the career center. Now, please remember, everything is digitalized now. Earlier, ROC, when you had to file physical forms, and now MCA portal, it is totally different. So similar thing is happening here. Earlier, employee exchange were like manual working was there everywhere. Now it will be digitalized and you have to report online, and the vacancies will be highlighted in respective career centers and the people will be able to apply. So it is just like Naukri.com or something like these big players are there. The government is trying its level best to have such system where the vacancies should be reported to general public, and the public should take advantage of that and should be able to apply for the jobs. And the companies also will be able to get the right candidate. So many people like that. So this is what my take on this.
Vaibhav has put one question. So form ER1 will be replaced form in EIR. This form is filed with the employment exchange on quarterly basis.
What is the question? This EIR employment information return, you are saying?
Employment return 1 will be replaced by EIR. That's what he is saying.
Yeah, current. Yeah, definitely there will be current whatever forms you are having. It will be replaced by the new forms. And
but as you rightly say, probably it will be available on the digital, on the media, so people will be able to see it at large. That's what you're saying.
Yes. It will be digitalized.
Okay.
Sure.
Okay, I think that is all the questions I have actually now.
Okay, sir.
Yeah. I think some other, although you initially said you wanted to leave early, actually, but because of the people interaction, etc., and all this thing, we will have to cross even the time. It is already crossed 1 o'clock.
Actually, I wanted to wrap up with
I must sincerely take an opportunity of thanking you for putting the things so lucidly. The session has really made very lively, thrown out a lot of things. In fact, I expect our fraternity people will take a lead on this. They will take an interest on this, and we can find out the new opportunities for the people of company secretary in the get into the area of new practices under the labor law. That is what I think. And as Mr. Sudhakar said, actually, he will take up the matter and he will actually talk to the people and all things will come.
Yes.
I think Jambunathan wants to say something. Yes, Jambunathan. Your hand is raised actually.
No. I said, I gave thumbs up.
Okay. Thumbs up. Oh, sorry. Thumbs up.
Great.
Okay.
So I would like to thank all the participants in participating in so many numbers and making this interactive, as Mr. Bala, Mr. Sudhakar, and all the participants who are interacting. It is really, this makes session very interesting and interactive and meaningful, basically. If I had to just give a lecture and just go, so there would not be any, it would not be that useful, but you are really, your experience also helped other people. So, and what I, as Sudhakar sir also said, that he will take some initiatives that proper awareness should be spread about these labor law. And I sincerely feel that all the senior people, what you say, it has some weight, and the people definitely will follow whatever you will say. So that is what I expect, that all the senior people will spread awareness about this labor law, and company secretaries will, explore this area in coming years. Thank you, sir, everyone, for inviting me.
Thanks a lot. Thank you very much.
Okay, sir.
And with this, I think we can close the session.
Yeah.
I really feel the session was very enlightening, very learning personally for me. And I also feel so to the participants as well. Lot of input, lot of interactions,
Yes.
lot of discussion, lot of clarification. Session was very lively. Thanks a lot to Mr. Shantanu. My sincere thanks to you.
Thank you,
If
sir.
there is anything, people can always get in touch with you. I believe your guidance will be available to our fraternity of the people. I
Yes.
think with this, I take the opportunity of thanking everybody, all the participants in this session. Thanks a lot. Thank you so much. We close the session with this.
Yes, sir. Thank you so much. And last point, if any participant is having still any question, like casual worker or something like that, you can send me your queries. I will try to respond to you on that. Okay. So thank you so much.
So nice of you, sir.
Yeah. Thank you, sir.
Thank you.
Okay.